thanks for joining us today for the PACT Act, Leave Sellers of Vaping Products in a Fog, the latest tax and legal considerations. I know this has been a really challenging time for everybody, trying to wrap their heads around everything, especially as the PACT Act the changes were passed last fall, but then we had been waiting patiently for the Postal Service regulations to come out. In the meantime, we still have had the tax implications. So this is going to go through really what's happening on the mailing side with the USPS and on the taxing side. And these are our esteemed presenters today. My name is Rachel Kurtz-McLean. I'm the Deputy Director of Public Policy with the National Cannabis Industry Association. And from Thompson, Hine, LLP, we have Eric N. Heyer and Joe Smith. And then from Cherry Bekaert, we have Lauren Simpson and Kathy Stanton. And I will let them give themselves a little more of an introduction when they each speak as we go along. So on today's agenda, I'll briefly discuss sort of what's happening mainly with the cannabis market, since that's my expertise. Then we'll go through the legal considerations of PACT Act licensing and reporting requirements. Then the compliance challenges of PACT Act, excise tax, and sales tax, and other state tax considerations. And then at the end, we're hoping to leave some time for questions. So if you think of questions throughout the webinar, go ahead and put those in the chat box, and I will compile them for the most kind of popular questions or the ones that maybe haven't been answered. And if it makes sense, we can kind of throw them at the speakers in the middle of it. But just know if you put questions in the chat box that we are seeing them, and we will get to them at the end if they haven't been answered during the presentation. So looking at the current industry and market trends, I'm sure you're well aware of the tobacco market and nicotine vaping. As far as cannabis goes, it's actually, I'm sure you're aware, a huge market right now, and it's only growing. There are 18 states plus the District of Columbia in this country that have an adult use market for cannabis, and 37 states have medical marijuana. And so, and the share of vape products within that is they're taking about 20% of the dollars of that market. So it's actually a really large market, and it's only growing because more people, kind of join the market and learn about all the different products and are able to, use something that's a little more discreet and maybe it's not as harsh on the lungs. So, as far as the legality, with those states have it legal, but we still have it. It's still, cannabis is still a Schedule I controlled substance. However, with the Farm Bill of 2018, they had CBD, anything that is a plant derived from a plant that has less than 0.3% THC is legal. So CBD products, for example, are currently legal under federal law. However, there's not much regulations at the federal level around it. But we do have these regulations, the PACT Act, which does affect cannabis and CBD vaping companies, and all the manufacturers of the devices that are used for that. So it's very important to understand how this is going to affect you. So with that, I will turn it over to our legal considerations of PACT Act licensing and reporting requirements to Eric Heyer.
Thanks, Rachel, and good afternoon, everyone, or good morning if you're on the West Coast or really anywhere other than the Eastern time zone. My name is Eric Hine. I'm a partner in the Washington, D.C. office of Thompson, Hine. I head up our vaping industry practice group, and we have a cross-disciplinary practice group. We cover litigation and taxation issues and IP issues, and really the whole gamut for those that are involved in the vaping industry on both the nicotine and the cannabis side of the equation. And so Joe Smith and I are going to be presenting today on some of the legal considerations surrounding the PACT Act and which products are covered and some of the requirements that the new legislation imposes on participants in the industry. So this is a quick overview of what we're going to be covering in sort of our half of the presentation today. What is the PACT Act? What products are affected, which is actually a very important question when it comes particularly to cannabis related products and devices related to delivery of cannabis and cannabis derived products. And we're going to talk about briefly for different people at different points in the supply chain, how they're affected by this. The focus though today is going to be, just because of the time constraints we have on our presentation, is going to be more on online retailers and the requirements applicable to them. But I don't want to give short shrift to manufacturers or distributors, because many of the same requirements, whether it's under the federal PACT Act or whether it's under existing state laws surrounding licensing and taxation, are in some way, shape, or form also applicable to them as well. And that's an issue about which there's been a lot of misunderstanding, I think, in the industry. And then a most recent vintage, we're going to talk about what do industry participants need to know about continuing to use the U.S. Postal Service, especially now that we've had the final rule, as it were, the final modifications to Publication 52 handed down here just last month. So let's get into it a little bit. What is the PACT Act? What's referred to in shorthand as the PACT Act, or the Prevent All Cigarette Trafficking Act, is really sort of two separate statutes. There's the Jenkins Act, and then there is the PACT Act itself. And they've actually both been around for quite a while, particularly with respect to combustible cigarettes and smokeless tobacco products. What's new is now the extension of these statutes and their requirements and their restrictions to vaporizer products, to vaping products. So right after Christmas last year, December 27th, 2020, as part of a 6,000-page COVID relief omnibus piece of legislation, Congress passed the Preventing Online Sales of E-Cigarettes to Children Act and extended these existing statutory requirements to ENDS products. And we'll talk about this in a second, but the way that Congress did it was to stick this new definition, which we'll turn to in a second, under the existing definition of cigarettes, and create a lot of confusion and a lot of lack of clarity in the statutory language and in the industry's understanding in the process. Now, it's important to note and really underscore this, that the legislation imposes new requirements on anyone that's shipping what's defined as an ENDS product, even though it's ENDS stands for electronic nicotine delivery system, as we'll talk about in a second. It's not limited only to products that contain or are intended to be used with nicotine, but anyone shipping the products that we're going to talk about in a minute across state lines for any reason. It's not just in conjunction with the sale, whether it be a wholesale sale or a sale to a consumer. You could be a manufacturer who is shipping a product across state lines to a testing laboratory in another state, for example, and a number of these requirements are still going to be applicable to you for that interstate shipment and that interstate delivery, even though it's not in conjunction with either a business sale or a consumer sale. Now, the other half of it, and Joe's going to talk about this a little bit more in his portion of the presentation, is the new requirements and the new and significant restrictions that the legislation imposes on what the U.S. Postal Service can deliver through the mail now as well, both for a B2B mailing and for a B2C mailing. This legislation had an incredibly short trigger when it was passed. The effective date was only 90 days out, and it took effect on March 27th, 2021. So even though we're now in November, I want to underscore these restrictions are now in effect, and we've actually started to see, just in the last month or so, the first enforcement activity on our end as well, for our clientele, from the Bureau of Alcohol, Tobacco, and Firearms, with respect to federal enforcement of some of these PACT Act requirements, which we had not seen a lot until very recently, but that's now starting to become more active. So let's talk about the statutory definition, and I apologize for the small font here on the PowerPoint, but this is actually very important, and particularly important when we think about what sorts of cannabis or cannabis-related or hemp-type products may or may not be covered by the PACT Act. So the statutory definition that Congress added is electronic nicotine delivery system. And this perhaps takes the cake as the most misleading defined term in the US code. The full language is here. The key language is that which I sort of underscored, which is there are sort of two things that are a touchstone. One is you have an aerosolized solution, an electronic device that through an aerosolized solution delivers nicotine flavor or any other substance, and that or any other substance is key language when we're talking about hemp and cannabis related or derived products, to the user that's inhaling from the device. And it doesn't matter whether the component, the liquid, the part, or the accessories we have highlighted down in red below is sold with the device as one integrated sort of kit or one integrated product, or whether it's sold separately. So this means if you're talking about a nicotine product, you could have a bottled e-liquid that even though it's not sold with any sort of a device, it falls within the definition. If you have a CBD oil that's sold separately, that also falls within the definition. And so the touchstone here is you have heating and aerosolization, and you have some sort of a substance that's being heated and aerosolized and delivered to the user. So those are the two key elements. We go on to the next slide. Okay, so what does this mean in terms of real world products that those in the industry, and particularly those that deal in cannabis related or hemp related products, what sort of products are covered or affected? Nicotine containing e-liquids absolutely are covered. Oils, my view is those are covered as well, right? You have a substance, you have a solution that's getting heated and aerosolized. Now, how about waxes and how about dry herbs or leaves? My view on this, and we don't have any sort of definitive guidance on this from ATF, but my view on this is, since these are not what I would consider to be a solution, right? They're not an oil, they're not like a nicotine containing e-liquid with propylene glycol and vegetable glycerin, that these sorts of products, or the perhaps a better way to say it is the devices that are intended to be used with only these sorts of products, waxes or dry herbs or leaves, do not fall within the definition. And we've certainly had a number of clients that we've dealt with where maybe they carry a mix of different types of vaporizers, where some are intended for use with oils or with nicotine containing e-liquids, where others very clearly the design is for waxes or dry herbs or leaves only. And there can be a distinction there about whether and which reporting and registration requirements apply depending on which product is being sold or being shipped across state lines. Now, this new definition of electronic nicotine delivery system that covers all of these things, including many types of products intended to be used with solutions that don't contain nicotine, were all placed under the existing statutory definition of cigarettes. So what that means in reality is that all the pre-existing requirements that were applicable to cigarettes are now also applicable to all of these products that have some sort of a solution that gets heated and that gets aerosolized. And that leads to sometimes some difficulties in interpreting and understanding exactly what the requirements are and which products they apply to under the existing statutory language. It's sort of trying to take a shoe that's a couple of sizes too small and fit it on your foot. So moving on to the next slide, please. Okay, so I'll go ahead and turn it over to you, Joe, now to talk about the different requirements for participants in the industry.
Great, thanks, Eric. As Eric mentioned, I'm Joe Smith with Thompson Hine, also working with the vaping industry as well as litigation, and also particularly with the cannabis industry, not only the marijuana cannabis, but also particularly companies and individuals working in or with the hemp and CBD and Delta 8 and all the various derivatives that are coming on the market from hemp. And so what I'm going to be talking about is some of the more specifics about how this can impact your business and what's going to be required to operate successfully and in compliance with the PACT Act. So this first slide is really a lot of what we're going to be talking about is going to focus on retailer. There's a big overlap with what's required not only of retailers, but of distributors and manufacturers. And this first slide lays out some of those requirements that if we could go back to what was there, that part, thanks. So the first requirement that applies to everyone, regardless of whether you're a manufacturer, distributor, or retailer, is the PACT Act requires you have a statutory or registered agent in every state you ship to. That's part of the federal statute, and it's just required. And I've explained a lot to a lot of people what a registered agent or statutory agent is. That's essentially basically just a company like CSE or U.S. registered agents or similar companies that essentially just have someone there in that state to accept process, like a lawsuit or a notice from an attorney general or the tax department or Department of Revenue, that then would be forwarded on to you wherever you actually are located. That's the first step, and one of the easier steps. It's you have to pay for it, but there's not a whole lot actually required for it. The next step or piece of it is registering with the ATF and the applicable state departments of revenue. If anyone's looked at this or done it, you know the form for registering with the ATF is essentially a one-page form laying out your basic information about your company, who you are and what you're shipping, and then your registered agents. And again, this applies to manufacturer, distributor, and retailer. And it's important to note on this, with all these requirements, that broad definition of ends, because it's not just the e-liquids or the oils, for example, but it's also the devices themselves. So if you're a company that's working with marijuana cannabis and you're saying, well, I can't actually ship across state lines anyway, my product, I don't have to worry about the PACT Act. Well, that may be true if all you're selling is the actual vapable or aerosolizing solution. That's true. You can't ship that across state lines, as is currently the case, as it's considered a controlled substance under federal law. However, if you're selling or shipping a device, you're still subject to the PACT Act and you still fall within this definition. So you still have to be mindful of that. Even if, say, 95% of your products you can't ship across state lines, if you're shipping any devices that can be used to vape those solutions, whether it's regardless of what it's for, you do fall within it. So you do still need to go through the registering with ATF. And then the bigger one and potentially more complicated one is the registering with applicable state departments of revenue. Now, a lot of the states will accept the ATF form with maybe some slight tinkering or just identifying your registered agent in that state. Other states have very state-specific forms where they want detailed information about the business you're doing in that state. And as we have here, there's some confusion about enforcement in non-excise states. Originally, most people thought, well, there were two camps. One, it's going to apply everywhere, or it's only going to apply in states where they tax, where there's an applicable tax. And a lot of that was unclear because most states didn't give any information until right around March 27th, when a number of states came online and said, we expect you to have registration, such as Tennessee and I believe South Carolina and a few others, proactively came out and said, we're going to require PACT Act registration reporting, even though we don't have a tax. And then there were a few states such as Nebraska, and I believe one of the Dakotas came out and said, we don't tax ends products. Please do not send us your registration and your reporting. We don't want that. We don't know what to do with it. And that goes to the next point, which is submitting the monthly reports, which Cherry Bekaert is going to talk about, which is something that you're going to have to do every month if you ship into states. Now, the requirements for a retailer, what you need to do. The big one is you have to comply with all state license requirements. And here it applies, and again, we're focusing a lot on retailers. So here, if you're a delivery seller, if you're a retailer, you have to comply with licensing requirements as if the sale occurred in that state. So for example, if you're a manufacturer or distributor, if a state has a requirement that a distributor is licensed before they can ship into the state, and that applies to out-of-state shippers or distributors or wholesalers or manufacturers, you do need to get a license. But if their state statute doesn't require that, that an out-of-state distributor get a license, then you don't really necessarily have to worry about it. Or what you'll see is a lot of states make distinctions, such as Illinois, for example. Theirs is not a straightforward yes or no. You have to look at, well, do I have an agent here, and do I meet requirements ABC before I have to register? With online retailers, if you do B2C sales, if you sell directly to consumers, you must register and obtain a retailer license with every state that requires a license for this. Now, what complicates that is obviously if you sell a CBD or a Delta-8 vaping product or a cannabis-related product, not every state has a CBD or Delta-8 specific licensing requirement. Now, some do. Some have started to bring them online and have requirements for if you're a CBD or Delta-8 product, you have to have a particular license. But in many of these states, the license that applies is a tobacco product license because you fall within the definition of what that state requires. Because then what you're looking at is some states have a definition similar to the federal and statute of or any substance, and so therefore that licensing requirement applies. Whereas others have a nicotine or tobacco, in which case you don't have to worry about. And there's about 15 states where there is some overlap, where their definition is broad enough to encompass CBD or Delta-8 or other cannabis-related products. And again, here we have the potential penalties of noncompliance, state civil or criminal charges, and up to 3 years in federal prison under the Jenkins Act. And the big one here, or the one that would be more immediate, most likely, is the civil fines that you can be looking at, because a lot of them do apply specifically to retailers versus wholesalers or distributors or manufacturers. And then the next is the other requirement, and it kind of goes hand in hand with the licensing, is the excise tax requirement. Again, not every state has an excise tax applicable to ends at all. There's about, I believe it's right around 30 or a little more than 30 now. But again, even within that, similar to licensing, not all those taxes apply to cannabis or non-nicotine or non-tobacco products. Again, it's around 15 or so right now. Though that's regularly changing as more states decide how they're going to handle these products. And unfortunately, without a lot of federal guidance on how to handle things like CBD, a lot of states are kind of playing it by ear. And so looking at imposing CBD or hemp-derived product-specific taxes as well. And so, we have here, it does not apply to manufacturers and distributors. That's true in most cases. Most of the excise taxes apply directly to the retailer or the final sale. However, some states do require the tax be paid by wholesaler or distributor, and they are very explicit about how that's supposed to be handled. Nevada being one example that we've had come up, and how they want it collected and paid into them. And again, and the excise tax, sales tax, the related taxes, that's something Lauren and Terry Bekaert are going to be talking more about. But again, here, the non-compliance with the registering and the payment of tax, again, comes back to state civil or criminal charges and up to 3 years in federal prison under the Jenkins Act for violating these requirements. So now we come to what, if you're an online retailer, may be, frankly, the biggest hurdle that you may be facing right now, which is the USPS prohibition on mailing of ends products. This was something that USPS was supposed to issue their rule back in April, and they only now put out and published the final rule on October 21st. And under the rule, effective immediately, all end sale or shipments to the USPS are prohibited. So you can't ship anything, whether it's to consumer, other businesses, government, anyone. It's prohibited through USPS. Now, and that's regardless of whether it's nicotine, cannabis, Delta 8, CBD, any product basically that if it falls within the definition of ends, it can't be shipped. And USPS in their final rule, to their credit, they did address that issue, because a lot of companies and a lot of industry associations and groups all raise this question of, we don't sell tobacco products. Why do we have these requirements? Can USPS make exceptions or allow us to ship? And USPS came back and essentially said, the law is the law. We have to follow the statute, and it says you can't ship this. So unfortunately, even if we were to agree and say CBD is not a tobacco product and shouldn't be covered under the statute, we still have to prohibit its shipment. What this final rule does provide, though, is a business purpose exception, which the purpose is to allow for business-to-business mailings, but no direct-to-consumer mailings. So if you're a retailer, this doesn't really help you, to be honest. You've got to look for alternative shippers, whether it's through FedEx, UPS, or another carrier. But if you're a retailer that also does wholesale or distribution, this is a potential option for you to keep going and stay in business with that aspect. Because while the business-to-business exception is not automatic, businesses can apply for this exception and seek to approval from USPS to ship to other businesses, whether it's retailers, distributors, whoever it may be, through USPS. And again, they just put this out. They put out a very detailed rule. A number of forms are required, and the application, as we have here, requires a substantial amount of information about the shipper and receiver and the products being sold and shipped. So you have to identify not only who you are and your background, but also who you're shipping to, what you're shipping to them, and what you're potentially going to be shipping to them, not just on this shipment, but essentially you have to anticipate in advance what products you may ship to other businesses. And so and part of that includes identifying what that product is. And if it's a CBD or a Delta 8 product or anything like that, you have to identify that product and what its THC content is. That's something specifically included in the rule. So if it's Delta 8 product, you have to identify the amount of Delta 8 THC in that product. If it's a CBD product, you have to identify the amount of THC that's in the product. And hopefully, if you're shipping across state lines, it's less than 0.3% Delta 9 THC. But it requires a lot of upfront information. And then also with each shipment, you have to provide information about what's being shipped, who it's being shipped to. And it's not just well, I've got approval and now I can ship anything. You still have to go down to a USPS facility and drop off that shipment. They can't come and pick it up from you because USPS says that won't allow them to verify things like appropriate age and identity of shipper, or approval of the recipient. Because again, you essentially have to get approved not only for yourself, but your recipient when you do this application, and that requires providing proof of licensure or ability to do business in these jurisdictions. So as part of your application, you've got to show not only that you have a license to do business in, say, Illinois, but also that whoever you're shipping to has the appropriate license. So if they're required to have a CBD license or a vapor product license in a state, you essentially need that proof. You need that verification as well. And you can't just say, I've got approval, I can ship to anyone. That's unfortunately not the case. And now the last point on this is the PACT Act does not mandate FedEx and UPS stop carrying ends. Those were business decisions. We know some people are still able to and have not had problems shipping with FedEx and UPS. Other people have, and so their products are not getting through. It has been a very case-by-case situation. They have this overarching policy of not shipping it, but there does appear to have been some exception, whether it's intentional or just to date they've slipped through the cracks. So that's kind of, I know we kind of went through that quickly. There's a ton more with the PACT Act to discuss, but we could be here for hours. So I'm going to turn it over to Lauren Stinson and the great folks at Bekaert to discuss some of the excise tax and sales tax and other compliance issues with the PACT Act.
Thanks so much, Joe. Welcome, everybody. Thank you for taking time out of your afternoon or in some cases out of your morning to join us. As Eric and Joe have mentioned, there's been so many challenges around the introduction of the PACT Act and all these different regulatory requirements that I'm going to spend a little bit of time talking about the compliance challenges around the PACT, excise, and sales tax. So for PACT Act, we started working with companies in this industry around the PACT Act, obviously last spring when it came out. And there was just so much confusion. The states were very ill prepared to handle the incoming PACT Act requirements. And there really wasn't a lot of guidance. The first several months, there was a lot of confusion. But fast forward 6 months, we're about 6 months later, there's now more guidance by the states and more helpful information. But what we have seen is that the states they're requiring a lot of the same information, but in various different reports. So when we look at kind of the similarities between the states, so they're all obviously requiring the monthly reporting, but then that's where it really starts getting a lot different. So the states are requiring all sorts of different information on these PACT Act reports, but they all seem to have a different look and feel. So some of the information that they are requiring is customer details, such as the name, address, the zip code, the type of customer you're selling to, the product information like the UPC, the manufacturer's wholesale list price, the retail price, the brand family, invoice details, quantity of products sold, total weight of products sold, delivery service details. So just about every single conceptual piece of information surrounding the sales, the states are wanting this information in various different types of reports. And several states actually require signed specific forms. So the forms themselves are different as well. So it becomes just a very large compliance nightmare. So as far as submitting the reports, even that becomes a compliance challenge because some states will require the reports to be emailed. Some states will require the reports to be mailed, and in some cases to two different departments at the state. Some will require them to be uploaded into a Department of Revenue portal. And that's been evolving as well since the PACT Act was initiated for the vaping industry. But the huge challenge that we run into is that these reports are due on the 10th of the month. So if you are selling into a state, you're offering products for sale into a state, you've got to comply with these PACT Act requirements in all the states, and they're due on the 10th of the month. So you can see that there's just a huge compliance to get all the data extracted out of your system, formulated into the various types of reports that the client or that the Department of Revenue needs, and then actually sent in. So you've got a large compliance challenge around the PACT Act. Now, I've been asked several times if I think there's going to be any simplification among the states. And my background is in sales tax. And in the world of sales tax, the states have been trying to simplify sales tax for 25 plus years. They really haven't been successful in simplifying among states. So do I think that they're going to simplify the PACT Act? My crystal ball says no. Okay, so the next type of tax that there's also the compliance challenges around is the excise tax. So as Joe mentioned, there are 31 states that impose excise tax. Now this 31 includes Puerto Rico and the Virgin Islands. And there's also some localities that are starting to impose the excise tax as well. And when you calculate the excise tax, again, it varies from state to state because that's what makes it interesting. But the excise tax becomes a function of the customer type that Joe mentioned, the product type, such as an open system or a closed system, the unit of measure, so a percentage of wholesale cost or a per milliliter charge or a per stick charge or a percent of product value or retail value. So how you calculate excise tax, again, varies from state to state and even different types of customers as well. And then, of course, with actually the practical matter of filing the returns, you've got frequency changes from state to state. Some states will put you on a monthly basis. Some states will put you on a quarterly basis. And it really depends on the state and the volume of the tax that you are remitting. Obviously, the more tax that you owe, the more frequent you are going to have to file the tax return. And then as far as actually filing the return, again, it kind of varies like the Pact Act reports do. In some cases, you upload it into the Department of Revenue portal. Some states require the paper return, and in some cases, you can email the return with and send in the payment as well. So again, all sorts of different ways to handle filing the excise taxes from state to state. And then as far as due dates, the due dates really range from anywhere as early as the 10th to the end of the month. So again, just the excise tax compliance is another huge compliance challenge for this industry. And another question I get asked frequently is, do I think that states will impose more excise taxes? And I think that the answer is probably yes, just because of the popularity of the products, and sin taxes are an easy target to tax. So I think we will see more states imposing more excise taxes. And then my favorite tax is sales tax, because that is my true background is sales tax. And sales tax obviously transcends across all retail industries. And if you can go back one slide, that would be great. And sales taxes are they're a major revenue generator for most states, and the states take sales tax obligations very seriously. It is a trust tax, so with a trust tax, there's a higher level of responsibility for businesses to be compliant. Not paying sales tax can put you in jail, and it's also very important to understand that as a responsible party, so either a business owner or an operator, they can be held liable for sales tax, even uncollected sales tax, and it's not dischargeable in bankruptcy or the dissolution of a business. So it's really important to understand what a company's sales tax obligations are and being able to fulfill those sales tax obligations. So to understand where you have sales tax obligation, we first have to get to the concept of nexus. And nexus traditionally has been with a physical presence in a state. So you could have offices, you could have employees, you could have independent sales reps, you could have inventory in a state, you could have any sort of physical presence or any sort of a touch point within that state, and the state can impose sales tax obligations on your company. So looking at your whole set of business activities to determine where you have that nexus, that connection, that physical presence, that physical connection with the state will give rise to sales tax obligations. Now, then a new concept around nexus also is called economic nexus. And this stemmed from a Supreme Court case in 2018. So it's a fairly new concept. And it used to be that a precedent set by the Supreme Court case Quill said that a company had to have a physical presence in the state in order for the state to impose sales tax obligations. What Quill said is that simply selling enough into the state can trigger economic nexus and give rise to sales tax obligations. So the challenge is, what is enough into a state? And of course, the states vary from state to state. And you can fast forward or go to the next slide. So in some states, so you can see 25 states. So the majority of the states will say that selling $100,000 of sales into a state or 200 transactions. And mind you, 200 transactions can be a very small amount of sales. That is enough to trigger sales tax obligations in half the states. Other states, you can see some have eliminated that transaction count, and they're only using sales volume from 100,000 to 250. the largest states, California, Texas, New York, they're saying that $500,000 of sales into a state can trigger sales tax obligations. So it's very important to really understand all the different complexities of where sales tax kicks in to make sure that if you should be collecting sales tax and remitting sales tax, you are. So now some practical issues when you are selling B2C. Typically a sales tax engine is going to be necessary to allow your billing software or your shopping cart to be able to collect tax on the right products at the right rate for the right states. And a lot of time and configuration needs to be spent to make sure that that tax engine is correctly configured so that you are properly collecting tax. Now, even if you are selling B2B, in some states, you may still need to have a sales tax license, and you may still be required to file returns, even if there's zero tax due. B2B are always going to be exempt. We're usually going to be exempt from tax because of the customer can provide a resale certificate. And it's very important to make sure that all your exempt sales are substantiated with a resale certificate from your customer. And then obviously just around, filing the returns, some of the biggest challenges are the local tax allocation. So a lot of states impose not only the state sales tax, but city tax and county tax as well. And on the returns, it's necessary to break out all the different components of the tax that was collected. So break out the state, break out the city, break out the county. Then like the excise tax, there's filing frequencies. So you could be on a monthly or quarterly basis. Again, the more tax you collect, the more tax or the more frequent you have to file your returns. Most states have where you can do an upload onto the Department of Revenue portal or an EDI transfer. So that part is very consistent from state to state. And then the due dates are, most states they're due on the 20th of the month. There's a few outliers, but most states have a return that's due on the 20th of the month. So, obviously you can see, from the PACT Act, from the excise tax, from sales tax, in order for companies in these industries to be compliant, there's a lot of data that needs to be sliced and diced, and reports that are generated and returns that are prepared, reports and returns that are mailed, payments made, documentation kept, notices handled. So we've put together a compliance solution for our clients to really simplify their compliance needs. So we've developed an end-to-end solution where we get our clients' data at the beginning of the month, and we work through this whole process. So preparing each individual PACT Act report, getting it approved, getting it filed, creating all the excise tax reports, getting them approved, getting them filed, preparing all the sales tax reports and getting them approved and getting them filed and getting all the payments made, and then handling any notices that come in as well. So, it's been a work in progress for the last several months, and we're very pleased with the progress that we've made, really providing, coming up with a solution to meet our clients in this industry. And we'd be happy to share, any additional information for whoever needs it. And on that note, I'm going to turn it over to my colleague, Kathy Stanton, to talk about some other state tax considerations.
Thanks, Lauren. And I'll speed it up a bit because we're a little bit behind. So I want to leave some time for questions at the end. But I will say that my section isn't as exciting because you generally don't go to jail for the types of taxes that I'm talking about. And for sales tax, excise tax, and the PACT Act reporting, that seems to be definitely a component there. But I want to talk about some of the other taxes. If you are shipping or selling into a state, there are other taxes that can apply, and you need to just be mindful of that. There are some states that have gross receipts taxes. The most common, or the most probably well known, is the Washington Business and Occupation Tax. It's a gross receipts tax. If you're just shipping enough product in there, you also owe that tax. Ohio has a commercial activity tax. There's a couple other states as well. But income tax comes into play also. And income tax obviously is not going to be a big issue if you're not really profitable. But the more profitable you are, the more sales you have spread out in the various states, the more potential income tax obligations you may have as well. And it's important to look at your income tax obligations, because if you are, for example, a flow-through entity and the owners live in a state where all their income is being taxed, then it's just a matter of which state gets the tax, because you get a credit in your home state. So you really don't pay additional tax necessarily in a flow-through entity environment with an individual living in a taxing state. But if you don't file and you get caught, there's no statute of limitations for income tax returns. You could end up paying double tax. So a lot of different elements there on the income tax side. But with regard to economic nexus simply means I never stepped foot in the state, never did anything in the state. I only shipped product or provided a service that the benefit was received in that state. The states have been very successful in imposing income tax. So we get a lot of sophisticated clients that still are very upset that they're not doing anything in a state, and yet they have to file an income tax return. If you have customers and revenue coming from a state, you need to address the income tax. Next slide. So Federal Public Law 86272, this could be applicable to potentially a lot of people on this webinar. If the only thing the business is doing is selling into the state and it's only tangible personal property. So if you only solicit for tangible personal property, you could even have sales reps in the state, but if you're only soliciting for sales of tangible personal property, you may qualify for this Federal Public Law 86272 protection. It's important to understand that it applies only to income tax, not net worth taxes, gross receipts taxes, or anything else. Only sales of tangible personal property. So anytime there's a service provided or an intangible property sold, it's not going to cover it. It's only related to interstate commerce, not foreign commerce. And if you are organized, and then also sometimes the state will say even licensed or registered in the state, that causes a filing obligation. So if you have to become licensed due to the PACT Act, that may result in a requirement to file as well. I wanted to just make everybody aware of the Multi-State Tax Commission is a government, quasi-governmental group. A number of states are members of the MTC. Just in August, they revamped their guidance on how they are going to apply Public Law 86272. This is a law that's been in place since the 50s. And we did not have any internet commerce in the 50s. And so they're trying to modernize the guidance. And this is actually the 4th revision. But what's really problematic here, if you read this definition, is that if you are interacting with your customers at all through a website that is not just purely a shopping cart solicitation of sale, if you have post-sale chat, anything like that, the states are taking the position that that is an activity in the state that loses this federal law immunity. So you can go to the next slide. I've listed a few things here: post-sale assistance, the business solicits and receives online applications for credit cards. Even if you post that we have non-sales positions, if you would like to work for our company, upload your resume, that creates income tax nexus now. Here's a few more on this slide. Internet cookies, if you're placing internet cookies onto computers for data analytics that are not related to just the shopping cart and the shopping cart working, that's income tax nexus. Remotely fixing, upgrading products, which probably doesn't apply to this audience. Warranty plans, if they're sold, all of those things, income tax is not protected under federal law anymore. We can go through these final ones, and these are marketplace facilitator, probably not as much in this audience, but anything sold through Amazon or anything like that. And you have inventory in the state. Any inventory in the state is also going to create an income tax obligation. Okay, I just want to spend just 1 minute or 2 minutes. We'll open up for questions, but this new pass-through entity elections. If you've been listening to the news with regard to infrastructure legislation that's sitting on Joe Biden's desk, the state and local tax cap, this is the amount of state and local taxes you can deduct on your itemized deductions on your federal income tax return. The Tax Cut and Jobs Act limited that deduction to only $10,000. And that is a very hot sticking point for large Democratic states that have a lot of taxes, that the federal taxes have increased for their residents because this deduction is not allowed. Well, there's a SALT cap workaround that the states have been implementing, and there are now 20 states. The majority of those have just implemented this or legislated or approved legislation this year to get around that cap. And it relates to if you have a pass-through entity, you can check the box if you or make the election if you have state-sourced income that's significant in any of these states listed. You would want to look to see whether this election would benefit you. For example, if you had a very profitable company, you're paying $200,000 of state taxes, you can now elect to pay that at the pass-through entity level and just created a federal tax deduction. Now, I'm oversimplifying it because this is actually a very complicated area, and who qualifies and whether you would receive a benefit or not depends on what states you reside in and a lot of other things. But what I'd like to mention with regard to that as well is that in the infrastructure plan there that I mentioned before by Joe Biden's desk or President Biden's desk, there is a change in that cap. They've increased the cap to $80,000. So $80,000 of state tax may be deductible if that is signed, which I believe is expected. So I rushed through that, but I'm hoping that gives you a flavor of the income tax and some of the other tax obligations. Anytime you're selling, shipping into a state, you really need to talk to your tax professional to find out what kind of other tax obligations you may be subject to. So I'll turn it over to Rachel. I know we've gotten some questions, whether you want to ask some of those to our panelists or speakers, that would be great.
Yeah, thank you so much. Let's see. I guess we'll get to the kind of a broad question. I guess if you could kind of clarify, maybe Eric, your end. And, you know, for instance, and this is a good, this particular product is something that does not really, like I'm not even sure, you inhale the air around it, but it's non-aerosolized, but it's still something I think you kind of inhale, just a flavor, just that it's supposed to help with getting rid of the behavior, addressing the behavior of vaping.
Yeah, Rachel, and I don't know if anyone can see me, but yeah, I think if we go back to the statutory language, I don't know if we can go all the way back to that. I think it was about the 7th slide in, but the statutory language is very clear. It has to have, and it's an electronic device that through an aerosolized solution delivers nicotine, flavor, or any other substance. Now, you do have the language that talks about a component, liquid, part, or accessory, but if as the final product is used, and I'd obviously want to know more, and I'm not going to say this is like legal advice. We usually have that sort of disclaimer whenever we do a presentation like this, but just from the brief description, if it's something that's not getting heated and aerosolized, I would have real questions about whether it falls within the scope of the electronic nicotine delivery system definition that we see in the statute, because the statutory definition is very clear that there has to be an aerosolized solution as part of the definition.
Okay, great. Yeah, and so that means if something is like just smoking, like that's with the dry flower and herbs, and that wouldn't, it's not aerosolized, correct? If it's just kind of the smoke.
Yeah, I think that would be right. It has to be an aerosolized solution. Yeah.
Yes. Thanks for that. And there's also a question about kind of a timeline for, does anybody have any clue about a timeline for the USPS to be granting these exceptions? And also on like, then the timeline kind of for enforcement.
Yeah, so I can speak to that, Rachel, a little bit. So I know at least one of our distributor clients that was on the early side of getting their business purpose exception application in. They were told to potentially expect a response as quickly as 2 weeks, which to me would be mind-blowingly quick, knowing the amount of documentation that has to go in with it, the number of customers that they're planning would like to be able to mail to, and knowing, and as the USPS has stressed many times, that they were not given an additional cent in appropriations by Congress to be able to deal with this avalanche of business purpose exception applications. I've not heard back yet that anyone's actually had one granted. I just know that that they were sort of told that after they worked through the USPS staff, kind of resolving some initial questions and points of clarification about their application. So if that happens and it's that quick of a turnaround, great. Kudos to USPS. I wouldn't necessarily expect or plan on it happening that quickly though, especially because they are, if they're not already inundated, they're probably about to get inundated. On the enforcement side, I know there was a question in the chat about that. We started to see at the beginning of October, and this is the first one that I've seen, and we've been representing a large number of clients sort of at all levels of the distribution chain, online retailers, distributors, manufacturers. And this had to do particularly with a nicotine distributor of nicotine products, where one particular state made the allegation that they had sold while their license application was still pending, and that they didn't actually have a license yet. And ultimately, and I think it was maybe because of an issue having to do with the email address that was listed on the registration no longer being valid and hadn't been updated for the client. But ultimately, that State Department of Revenue kicked the issue up to ATF. We're still actually sort of working through it, and the client got a letter from ATF, which if you read the statute carefully, the statute contemplates potentially getting a notice that you'd be put on sort of the blacklist of companies that are engaged in unlawful B2C shipping of ends products. And if you are put on the blacklist, it prevents any sort of a common carrier from shipping for you, or they're in violation themselves. And so we've been dealing with that, but that was actually the first instance that I had seen of ATF actually invoking the PACT Act in terms of any potential enforcement activity against anyone. Certainly not not someone getting threatened with criminal, penalties or civil penalties, at least at this point. They have been sort of, it seems like preliminarily somewhat flexible in trying to work with us, but that is the first enforcement activity I've seen from ATF. So I thought that was noteworthy.
Yeah. And just to add to that, that letter from ATF actually, even though that company was nicotine based, the ATF actually specifically references that it could include hemp oil vapor products as well. So the ATF is already making it clear that it would or could consider those products under the PACT Act and the need for compliance as well. So they're already aware of, and not limiting potential enforcement to nicotine companies.
And was that the enforcement around mailing, just to clarify, or around taxation?
It was around licensing and not around using USPS. This actually predated the 21st of October. So it was actually, it had to do with shipping into the state. I'm not sure, I don't remember offhand what the company was doing in terms of the monthly PACT Act shipping reports, but somehow or other, the state became aware of the fact that they were shipping into the state and didn't yet have an active distributor's license in that state, which was required under state law. So that's that, and then that sort of turned into issues about had they submitted the necessary reports, et cetera. And then it got kind of kicked up to ATF. So.
Yeah, and that's kind of another really good question. This final rule that came out recently was from the USPS. And so what they've kind of decided are definitions of ends and, what might not be a definition of ends is really it's their rule. And so the ATF might have a different view potentially, like they don't follow the USPS rule. Is that correct? And somebody was wondering about, could the ATF confirm whether a specific product falls under the PACT Act? Did they, they've asked them about it and they don't seem to know much about it. Do any of you know like how the ATF is kind of treating it this similar or not to USPS?
Yeah, my thought on that, I go back to the spring where I was calling actually ATF field office here in my home area of Northern Virginia, trying to get some answers on some things. And it was funny because the agent that picked up said, well, these days we're pretty focused on guns, not so much on tobacco, which I thought sort of pretty well summed it up. But, in theory, the two agencies could have slightly different interpretations of the statutory language. The reality is, I don't think that they probably will. ATF, right after this came out, sort of gave some informal guidance at conferences and that about where they were going to enforce and if they were going to enforce in states where there were not at that point nicotine excise taxes, for example. But even then on that, we started to see then some of those states say, well, we're still expecting to receive the PACT Act shipment reports and registrations, et cetera, even if we don't have an excise tax on those sorts of products. So in theory, you could have two slightly different interpretations. The reality, though, is I don't expect that would happen. I'm not aware of a particular mechanism to sort of approach ATF and get any sort of a definitive ruling. There may be some way to get like a letter opinion from them, but I think generally our experience with our clients has been we've thought the questions that we've been presented, generally they're fairly cut and dried in terms of kind of definitional issues around products. We haven't encountered that need to potentially go back to the agency and seek clarity from them, at least up to this point. And I wouldn't expect that if ATF does push something out, it would be particularly different from USPS. The one area where there is a lot of, let's say, a lot of confusion, where what ATF has said is not totally clear, has to do more with international shipments coming into the U.S. and where and when international shippers may or may not have to register, because there's some old guidance that they put out under the old version of the PACT Act and the Jenkins Act, when it was just for cigarettes and smokeless. And that has not been updated, so that's the best guidance that we have to go off of. But there are definitely some sort of blurry lines in there, so that's an area where we could certainly use some additional clarity from ATF, I would say.
I want to thank all the panelists here and really great attorneys from Cherry, Bekaert, and Thompson, Hine.